My name is Attorney Barton Morris. I am a practicing attorney here in the city of Royal Oak. I can be reached at michigancriminalattorney.com. I've been doing this the past 20 years, and it's come to my realization that a lot of people have questions, and so we're going to do some videos about it. Today's video is going to be about being in possession of a firearm while under the influence of a controlled substance or alcohol. It is becoming increasingly common where somebody is in possession of a firearm or potentially has a permit to carry a concealed weapon and perhaps may also be consuming alcohol and come into a situation where there may be being in possession of a firearm while under the influence of alcohol, especially when it comes to a motor vehicle. It's very important to try to clarify these things, make sure people understand what's legal, what's not, and under what circumstances they could be in serious trouble. So first, with respect to alcohol, there are different levels of alcohol in somebody's body that equates to the type of offense that it could be prosecuted for. An individual being under the influence, meaning that having a bodily alcohol content that exceeds 0.10 grams per 210 liters of breath. If you're in possession of a firearm, that's a misdemeanor, punishable by up to 93 days. And in particular, that particular one, your license will be suspended, or excuse me, revoked, meaning that you can't get it back. So that's a pretty heavy penalty, and people don't really understand that if it's above a 0.10. Now, that is different than being between 0.08 and 0.10 grams per 210 liters of breath or blood. That penalty is same misdemeanor, 93-day maximum penalty, but that license will be suspended for 3 years. The permit to carry a concealed weapon suspended for 3 years. The third level is having a bodily alcohol content between 0.02 and 0.08. That is not a misdemeanor, that's actually a civil infraction, although it still comes with a penalty of a license suspension, but that's only 6 months. So you see there is a significant difference between those three levels of being in possession of a firearm under the influence of alcohol. And then you might say, well, then what is exactly in possession of a firearm? What if a firearm is in the glove compartment and the individual is driving a motor vehicle? Well, if the firearm is in the glove compartment, it is accessible within the passenger compartment, and so even though it might not be on their person, it's still being in possession of it. Now, if the ammunition has been removed and is placed in another location that is not accessible in the passenger compartment, then that is permissible. But not necessarily just in one glove box like the ammunition is and the firearm is in another one, for instance, in the same passenger compartment. That is still in possession of a firearm that is going to satisfy the definition of the particular criminal offense. But if the ammunition is in the trunk, for instance, then not really accessible or not accessible at all within the passenger compartment, that does satisfy that requirement where it is no longer, an individual is no longer in possession of a firearm under the influence of alcohol. So you can probably see how a lot of people can be confused about exactly what the law is with respect to that. And then it gets even a little bit more complicated when it comes to a controlled substance. And in particular, generally the most commonly used controlled substance are marijuana and then of course prescription medications. And we could talk about what it is to be under the influence of marijuana and certainly under the influence of a prescription medication. But in general, the penalties are quite severe because under the influence of marijuana and or combination of marijuana or controlled substance like prescription medication and alcohol, the penalty is, there's no like three-tier level. It's simply revocation, misdemeanor, punishable up to 93 days, and a revocation of your permit to carry a concealed weapon. We can talk really quickly about the fact that a lot of people are interested in, can somebody have a medical marijuana card and also legally carry a concealed weapon? We get into federal law a little bit about that because federal law says that an unlawful user of a controlled substance cannot also be in possession of a firearm. That's a felony pursuant to federal law. And really, it's like it can even be somebody can be locked up for 5 years because of that. But just because somebody has a card doesn't mean they're actually using. So I know lots of people who have gotten their medical marijuana card but no longer use medical marijuana. People can, their debilitating illness could stop, for instance, or they simply choose not to use it anymore. So just having the card doesn't mean that somebody should not or cannot be in possession of a firearm. But being under the influence of marijuana, on the other hand, is strictly prohibited. You cannot be under the influence of any controlled substance and a firearm. The penalties are severe. If you have any questions, you can contact me through my website at michigancriminalattorney.com. You can contact me directly at my email address at barton@bartonmorris.com. And thank you very much for your questions, and feel free to give me some other ones and I'll do a video about it.